one another, suggesting that the judgment she delivers, and indeed judgment in general, is not simply an individual act, but an implicit or explicit recognition of plurality itself. Is this a plurality that judges? If so, what kind of plurality is it? Can we take our cues from her own use of the plural we in this final sentencing? Arendt presents her written voice as belonging to a plural subject when judging. She is herself, but also part of this larger humanity. What she judges Eichmann for is precisely the right he and others asserted to distinguish between the plurality of humans to which they wanted to belong and that plurality they thought they could not only exclude but destroy. His crime was then a crime against plurality, and it's in the name of plurality, if not the voice of plurality, that she not only judges him but condemns him to death. Of course, Arendt does not have the power to sentence him again, so the act of sentencing she performs is hypothetical, retrospective, wishful, ideal. She's not satisfied with the way the Israeli court issued its judgment. It acted as a nation and even deployed the scene of legal decision for the purposes of nation building. And it judges not the man, but another nation. For Arendt, the crime and its punishment cannot remain restricted to the language of the nation state. And though the meaning of plurality is not yet clear, it operates as one alternative to the nation, even as an antidote to nationalism. So the crime at issue is neither committed by an entire nation nor committed against an entire nation. Rather, the crime commits a breakage or rupture in plurality that by definition, plurality that by definition cannot know nationality, cannot be bound by nationality, and finally ought not to be. The we that Arendt invokes clearly provides the legitimating ground for her own final judgment, as fictional as it is powerful. Does the we whom Arendt invokes at the end of the text actually exist, or does the invocation become the legitimating ground that she finds everywhere lacking? In other words, does the pronoun do the work of aspiration, trying to instate a post-national framework for conceiving of plurality, one that would then serve as the basis for legal decision-making about crimes against humanity? This is a basis she finds nowhere actually instantiated in law. The we invoked at the end breaks with any we circumscribed by the laws of the nation state, any we that belongs to the nation. And yet it does not exactly describe some other we, except to say that such a we will be plural, internally differentiated, and that this internally differentiated population will serve as the basis of judgment, but also as the voice through which legitimate judgment takes place. This aspirational invocation of plurality seems to engage judgment, practical judgment in the Kantian sense, not as a way of subordinating an example to an existing rule, but as a spontaneous and even creative act. She asks us to consider human judgment not as bound by existing law, in her words, not bound by standards and rules under which particular cases are subsumed, but on the contrary, as that which produces its own principles by virtue of the judging activity itself. Only under this assumption, she writes, can we risk ourselves on this very slippery moral ground with some hope of finding some firm footing. Now, I wish I could think more carefully about this plurality that Arendt invokes at the end of Eichmann in Jerusalem, but for the moment I just want to say the following. She invokes a we who is judging Eichmann, and she seems to be imagining and embodying a judge. She is not. She's a reporter. She's a philosopher, even if she denies being a philosopher. It's a voice, on the one hand, rhetorically understood. It's also a ground. a voice that speaks as a we, but as one that is by definition divided up into many. It moves quickly between an I and a we, perhaps even lurches between the two. The same we serves as basis, ground, slippery ground, one on which no sure footing is to be found. In some sense, it is also a pronomial vehicle for hope. The ideal judge, whose conjectured voice ends this text as precisely one she wishes were true, hypothetical, a plurality, who nevertheless takes form as voice, the authorial and authoritative voice of Hannah Arendt herself. She's not a judge. She bases herself on no existing law, and yet she exercises judgment, one that deserves to be called critical, in her words, precisely because it depends on no existing law to ground its legitimacy. Now, one might expect Arendt to turn to natural law as a way to ground the legitimacy of positive law. Instead, she turns to a pre-legal understanding of responsibility or practical reason. You'll remember that the dictates or the conclusions of practical reason are supposed to become the conclusions of law. She not only makes the case for the priority of moral philosophy to legal decision-making, but she invests moral philosophy with a fictive, performative, spontaneous, and aspirational character that runs contrary to its usual modalities. After all, she's just staged a fictional scene in which she's a speaking judge. To what extent do we understand the staging of the fictional voice and position as part of moral philosophy? Arendt's direct address to Eichmann is not exactly argumentative. It enacts a judgment in the name of a conjectured plurality. In this sense, it is practical and performative, grounded less in existing legal code than in the non-existence of an ideal of justice, one that I might think better be described as a recognition of equality that follows from her conception of human plurality. So let's remember, Arendt obeys no law when she fictively sentences Eichmann to death. And just as she faults him for following existing law rather than questioning its legitimacy, she bases her judgment against him on no existing law, but only on independent judgment of what law should be. In this way, she not only makes philosophical thinking more primary than legal reasoning, but she also distinguishes responsibility from obedience, just as critical thinking is separate from the uncritical acceptance of dogma or dictate. One's responsibility cannot be understood as an uncritical allegiance to law, since law itself may turn out to be criminal, as we see in Nazi Germany, in which case we have a responsibility to oppose bad law, even a responsibility that would, under those conditions, be defined as disobedience. Indeed, sometimes disobedience is precisely our responsibility, and this is precisely what Eichmann failed to grasp. The difference, I think, between disobedience and responsibility turns on the plurality of the subject, the we who Arendt invokes when she levels her final judgment against Eichmann. The we she invokes against him is clearly also the we who Eichmann has sought to destroy, his ultimate crime. So when Arendt speaks as we at the end of the text, she speaks neither as part of an established court of law, and certainly not in the name of the Jewish people alone. She speaks in the name of a plurality that is coextensive with human life. Is there perhaps a universal principle or presumption in this plurality? Perhaps we can say only that there is a universalization at work that seeks to establish inclusiveness for all human society, but which posits no single principle as the common denominator of that humanity. Indeed, another time, one might consider how this notion of plurality, which does, of course, maintain its constitutive outside, nevertheless functions as a way of universalizing rights of belonging. We might also see how it does this precisely through a continuous process of differentiation. Equality does not operate as a principle that homogenizes